On a week when the Iranian people are marching against a terror regime, with the highest estimates of up to 20,000 protesters killed so far and well over 10,000 detained, we wish the protesters safety and success and freedom. And while the results of the uprising will undoubtedly affect us in Israel for the moment, the underlying lesson for us should be simple and sobering. We have the privilege, we have the luxury to fight our battles with words, laws, courts, and elections. The Iranian people are fighting for the very right to do that at all. Now, of course, here in Israel, we're still waging our own very different fights about democracy, and not even the threat of Iranian reprisal gets in the way of that. The latest flashpoint is a new bill to reform the criminal charge, which also plays a starring role in the cases against Prime Minister Netanyahu. It's called fraud and breach of trust. Now, is this reform a long overdue legal correction or a politically timed escape hatch? That's what we'll talk about today. I'm Aylana Meisel, and this is Basic Law. Now, Israel has a flair for performing real feats on the world stage, all while getting mired in its own internal tensions. One of the many dichotomies of Jewish life. Gefilte fish and mufleta coexist as treasured national foods. High-tech miracles occur alongside the bureaucracy of endless labor unions. We're constantly living inside of our differences, infighting about democracy with one hand and fending off the Iranian threat with the other. So where does this week find us? Well, the coalition is churning out bills on important issues without fully explaining their purpose. The Attorney General is seemingly attempting to crash the coalition by demanding the firing of Minister Ben-Gvir, despite the fact that he hasn't been formally charged with any wrongdoing, and tensions with the Haredi parties in politics, in the court of public opinion, and in the court itself could still lead to early elections. In other words, unusual business as usual. And just as usual, there is a huge information gap between what's happening in Hebrew and what you hear in English. We'll try to close some of that gap today, at least as far as this issue of the breach of trust offense, the law, the scholarship on it, the political history, and global trends to put things in perspective. And we're going to do it using a little magic trick. With the exception of a quick introduction, and when we wrap up, we're going to discuss this very important issue without using the words Netanyahu, judicial reform, or, for those that fancy a judicial overhaul, watch. So, coalition lawmakers announced this week that they're advancing a bill to repeal the crime of fraud and breach of trust, and those are charges that, as I said, all figure into the 3 corruption cases facing the prime minister. Opposition leader Yair Lapid called this proposal a full-fledged coup that will turn Israel into a failed, backward, third world country, and called to fight the madness in the courts and in the streets. I want you to remember that line for a little later in the show because it's important. Member of Knesset Yair Golan called this a mafia-like move. Meanwhile, the bill's sponsors argue that the offense is vague and superfluous and that it's basically been used inappropriately by the legal system to retroactively impose criminal liability on public servants and officials for things that aren't necessarily crimes. And that's about as far as most of the reporting goes. Now, we're going to be honest about the context. The timing looks suspicious. Okay, the coalition is pushing this bill while Netanyahu is on trial and soon after he requested a pardon from the president of Israel. And under Israeli criminal law, when an offense is removed from the books, that generally applies as well to ongoing legal proceedings. For Netanyahu, that would mean that the fraud and breach of trust charges would be dropped, unless the bill says something different, and that would leave only a bribery charge in the 4,000 case, and that's a charge that the court has already itself signaled that it finds unconvincing. Plus, the bill doesn't arrive in isolation. It lands amid a torrent of other proposals. The one to split the Attorney General's office, the one to make legal advisors subordinate to the politicians that they advise, the one to move the Police Internal Affairs Department to the Justice Ministry and out of the auspices of the state prosecutor. For those inclined to see the government as acting in bad faith, the narrative really writes itself. But this show exists for a reason. We want to widen the lens and to avoid replaying a familiar dynamic where Israelis themselves portray their society as sliding into fascistic oblivion, the language that helped fuel Israel's demonization well before October 7th. So before we even turn to the bill itself, which I will describe but never personally endorse, we do need to ask a prior question. Magic trick begins. We take Bibi out of the picture. What is the problem that the legislation is trying to solve? What is the offense of breach of trust? Okay, here's the law. Section 284 of the Israeli Penal Code states a public servant who, in the course of his duty, commits an act of fraud or breach of trust that harms the public, even if the act would not constitute an offense if committed against an individual, is liable for 3 years' imprisonment. So let's parse this. Public servant, clear enough. In the course of his duty, already murkier. Breach of trust, undefined. Harms the public, so vague that it borders on the metaphysical. And a penalty for all this ambiguity, prison time. Now, this law is an inheritance from the British Mandate, and it's modeled on, or loosely modeled on, the English common law offense of misconduct in public office. It's what Israeli law calls a framework offense, which is a statute that announces a general prohibition but leaves courts to decide case by case what conduct is actually forbidden. And that's where our problem begins, because framework offenses sit in deep tension with a foundational principle of criminal law, legality. You should not be punished unless the law gave you advance notice that your conduct was criminal. Now, when the statute says breach of trust without defining it, people only learn what the law prohibits after they're prosecuted. And this brings us to a distinction that often disappears in the public debate, and it's worth mentioning. Corruption and illegality are not the same thing. There's a wide gray zone of conduct that may look unseemly or unethical or politically distasteful, but which is not criminal. A minister appoints a qualified friend to a government post. Might look bad, but if the friend is genuinely qualified, should that maybe be a felony? A politician advances a policy that benefits constituents who supported her campaign. Is it public service? Could be. Is it political self-interest? Undoubtedly. And could it be both? Yeah. Is that a crime? A government official makes a decision that later turns out to be wrong. Was it poor judgment? Possibly. Was it something else that could later be interpreted as criminal conduct? Look, in a functioning democracy, we distinguish between unwise conduct, unethical conduct, professional misconduct, and crimes, and we have different tools for each. Elections and ethics committees and disciplinary proceedings, and only as a last resort, criminal prosecution. A vague breach of trust offense collapses all the categories together, and it allows prosecutors to criminalize conduct that they find distasteful, transforming institutional preferences into criminal prohibitions after the fact. Now, against that backdrop, we're going to take a quick detour, and just consider Israel's political culture. Professor Yossi Shane of Tel Aviv University in Georgetown has written extensively about Israel's language of corruption, as he calls it. In his 2010 book, he argued that Israel is unusually eager to probe and indict its political leaders. And his explanation is sociological. In a 2016 interview to JTA, he said that since Israelis cannot unite around territory, religion, or economic policy, there emerges, quote, an avalanche, almost an orgy of unity, to incriminate the political system. Corruption talk becomes a substitute for unresolved political conflict. It creates a vicious circle. Per Professor Shane, they say, the politicians are corrupt. Investigate. Well, how do you know that they're corrupt? Because there are investigations. To put this in global perspective, Transparency International's 2024 Corruption Perceptions Index shows that Israel's score rose recently from 63 to 65 out of 100, placing it 30th out of 180 countries surveyed, an improvement even as many democracies recorded their worst scores in years. Perception, however, is not the same as reality. Endless investigations can create the sense of pervasive corruption even when international comparisons suggest otherwise. Shane offers a telling historical example as to how flexible the standards have become. He said that when David Ben-Gurion was prime minister, he ordered books by Isaiah Berlin for his personal library using government funds. Today, that kind of behavior could trigger a criminal investigation. In that same interview, he mentions the overzealousness of the Attorney General's office, the scandal-addicted media. He talks about the corrosive effect that the corruption obsession has had on society, or could have on society, and the kind of law-breaking or totalitarianism that it can justify. Former Justice Minister Daniel Friedman, an Israel Prize laureate who served under Ehud Olmert, made a parallel argument in his landmark Israeli legal history, The Purse and the Sword. He described how the weakening of Israel's political institutions allowed the legal establishment to accumulate power. Since the 1990s, he noted, Israel has experienced an unprecedented wave of criminal investigations and trials of major political figures, unparalleled in other democracies. And some of those investigations were justified, but many were questionable, at least looking at them today. And at the center of this dynamic sits the breach of trust offense. Its vagueness makes almost anyone investigable. Now, let's move to what scholars have said. In 1999, Professor Miriam Gourarie, who's widely regarded as one of Israel's leading criminal scholars, if not the preeminent one, published a searing critique calling for the repeal of the breach of trust offense, or at least a critical reform, and she urged prosecutors not to use it and courts to drastically narrow it. In 2014, Gourarie described the offense's use as approaching a, quote, moral panic, the expansion of criminal law into areas better governed by ethics or discipline. Now, Professor Mordechai Kremnitzer, a prominent criminal law scholar as well, and a member of Israel's left, which I say in order to remove any suspicion of partisan affiliations here, stated at a 2010 Bar Association conference that the important principle in criminal law is the principle of legality, according to which there is no punishment without prior warning. In a catch-all offense like breach of trust, we don't know what's included. Therefore, on its face, it has no place in the criminal code. And in 2008, Professor Kremnitzer was one of several scholars who published an entire book about fraud and breach of trust through the Israel Democracy Institute. The book was sharply critical of the offense as phrased and recommended replacing it with specific prohibitions: conflict of interest, prohibited benefits, misuse of information, each with clearly defined elements that officials could know in advance. So, top members of Israel's criminal law elite have been remarkably consistent on this point. And dollars to donuts, they're not exactly the stuff of the Likud Central Committee. Now, perhaps the seminal case in which the concerns about this offense are directly addressed is even before 2008, in a 2004 Supreme Court decision called Sheves. Shimon Sheves, former Director General of the Prime Minister's office under Yitzhak Rabin, was accused of acting while in a conflict of interest in his position. He waged a long and complex legal battle, part of which eventually ended up in the Supreme Court, which initially acquitted him of illegality. But at the request of the prosecution, which claimed that the acquittal was harmful to the law on breach of trust, the court reconvened, and in the rehearing it reached an opposite conclusion, sending the case back to district court for sentencing on 2 counts of breach of trust. All 9 justices hearing the case agreed that Sheves' conduct was improper. All 9 also agreed that no tangible harm was done. Perhaps even in certain ways, the public interest had been advanced. His decisions were substantively reasonable. They were disclosed to superiors. But the court split sharply around the interpretation of breach of trust. Justice Mishael Cheshen warned that the breach of trust offense resembled the discredited crime of public mischief, which is an offense with, quote, no measure, not above, not below, not to the sides. Punishing acts defined as criminal only after the fact, he warned, could undermine the very foundations of the rule of law. We must not allow the law, he wrote, like a squid, to send its tentacles in every direction. Now, Justice Eliyahu Matzah, dissenting alone, described the expansive interpretation as tafasta meruba, grasping too much. And he noted the irony. All 9 justices agreed on the abstract definition of breach of trust, but reached opposite conclusions on identical facts. Now, if judges couldn't agree, how could public officials know where the line lay? The offense, Matzah concluded, remains as vague as it was. And now in the majority opinion, which was written by then President of the Court, Chief Justice Aaron Barak, things were explained a bit differently. He acknowledged the statute's indeterminacy but embraced it. Indeed, he wrote, like all valve concepts and open norms, this offense does not set a closed list of situations. It is the duty of the court to pour content into the protected values. We will not get into the details of what Barak considered sufficient to show criminal intent and criminal wrongdoing at any length, but they do reinforce the arbitrary nature of the law and its interpretation. I will, however, give you one more quote of his about breach of trust. Barak explicitly rejected the promise of advance certainty. Says our interpretation does not guarantee a mechanical translation of a general offense into a specific prohibition. All we can do is clarify the circumstances based on our intuition. Intuition. That is the basis of the fight against corruption under the current law. Possible prison sentences can be handed down based on intuition. Boosting the power of the prosecutor and the judge, and running politicians, historically both those from the left and the right, through purity tests whose rationales and outcomes are hard to gauge in advance. Now look, criminal law rests on a simple premise. Punishment is the most severe power that the state wields. It strips liberty, it brands people as criminals and shadows them for life. And because of that severity, it demands clarity. Laws must be precise enough that a reasonable person can know in advance what conduct crosses the line. Vague offenses violate this principle. They invite selective enforcement and after-the-fact moral judgment, and they resemble pre-modern systems where judges punished whatever offended their sensibilities. As interpreted, breach of trust does that today. It's important to understand that the critique of this overreaching breach of trust offense is not uniquely Israeli either. Across common law jurisdictions, legal systems have been moving away from broad catch-all offense. In the United Kingdom itself, a recent commission formally recommended abolishing the offense of misconduct in public office, arguing that its vagueness violates legal certainty and should be replaced with clearly defined statutory crimes. In Canada, the Supreme Court narrowed Section 122 of the Criminal Code, so it applies only to officials acting with corrupt or dishonest intent, not mere errors in judgment. In the United States, the Supreme Court sharply curtailed what's called on-services fraud, limiting it to explicit bribery or kickbacks to satisfy constitutional requirements of fair notice. Those reforms reflect a growing consensus that criminal law must be specific. And you know what? There was also an age in which Israeli politicians across the spectrum understood that need. So let's talk about that. Numerous bills attempting to reform this charge of breach of trust have been introduced, starting back in 2007. Now, we're going to mention a few. In 2007, that was a proposal by member of Knesset Avishai Braverman from the Labor Party, with co-sponsors including Shali Yachamovich, also from Labor and later its party chairwoman, Dov Chenin of the Communist Hadash Party, Yossi Beilin, who was the architect of the Oslo Accords, and Likud members Gilad Erdan and Limor Livnat. So, crossing a pretty wide ideological spectrum there. In 2010, the bill, or a bill, was put forward by Yochanan Plesner, who is now the president of the Israel Democracy Institute, and co-sponsored with Yariv Levin, who is now justice minister. Now, these two people today sit on polar opposite sides of the judicial reform questions, but they once agreed that this law needed fixing. In 2020, the reform proposal had co-sponsors including, remember what I said at the beginning of the show, Yair Lapid, the opposition leader who called this week's bill a coup. Now, there are a few others as well. None of the proposals advanced, and the reason for that often was that there was always some political bigwig under investigation where that charge had been leveled. But the previous support from Hadash to Likud shows that this doesn't need to be a partisan issue. Until recently, it could have been a matter of consensus. And so now that magic trick that we talked about has to end, and we move back to speaking about the current bill and the current politics. What does the 2026 bill do? Well, it eliminates the charge of breach of trust, yes, but it leaves in place specific offenses which can currently be penalized: bribery, money laundering, fraud, and the obstruction of justice, while also adding several new specific charges. These include a prohibition on conflicts of interest, of the first degree and a prohibition on insider trading. The bill also seeks to strengthen disciplinary and ethical rules in the public service. The criticisms of the bill have so far been political, as far as I've seen, and I have yet to see anyone taking the time to address it on its own terms and to show where it falls short of the standards that have been previously urged in the scholarship. So if anybody here comes across that, let's talk about it. Please let me know. For now, let's sum up. For nearly 30 years, Israel's leading scholars warned that this offense was fundamentally flawed. Judicial disagreement over vagueness and discretion was explicit. Legislative efforts were bipartisan and recurring. Now, who knows about the future of this bill? Is it real? Is it a political move in a larger chess game? Does it pass? Does the court then strike it down? I don't know. Either way, we're going into an election year, and you are sure to hear about this over and over again, and that makes the background critical. Ignoring the history here turns journalism into advocacy. Then again, to be fair, the politicians are not making it easy for anyone. The coalition does bear responsibility for explaining itself, especially given the political context. But serious analysis, regardless of that political gap, requires acknowledging that even badly timed proposals can rest on long-standing legitimate concerns about human rights and criminal law. So let's return to where we began. I look at Iran today and I am awed. I hope that we are watching a titan. The people of Iran free themselves from their chains. I hope that the West does more than watch and that it stands with this civilization that has been oppressed and repressed and abused for far too long and gives it the helping hand that it needs to remove the evil boot from its neck and this regime from our lives. And, again, there's no parallel between what's happening there and here. None. But the lesson that we have to take is precisely that. We are going through a hard time as we lay the foundations for success and prosperity, which Israel never formalized for itself. These debates matter, and they're important, and there are lives at stake now and for future generations. But what the Iranian protesters are risking their lives for is what we already have and what we should appreciate and keep in mind, no matter how tense that the law and politics get. The story of this place, its future, and the vast potential that its people have yet to achieve on all fronts is far bigger than any set of bills, any politician, any political fight. Let's continue to unlock it together.